Thanks for joining me again. This is night 8 of our 24 nights of live streams breaking down the American Union strategy for political reform, as well as all the details in the 311 pages of the Trump-Biden peace plan. It's the American Union's legislative demands for 2024, an upgrade to our social contract that will end poverty, end mass incarceration, end the endless wars. If you want to do that, Republicans and Democrats are not looking out for you. You need better representation. And that better representation comes in the form of a union, the American Union of Swing Voters. And together we can collectively bargain with our decisive block of votes across all 470 federal races and bring the candidates and the political parties to the negotiating table. Because as long as we have what they want, the winning block of votes, they will be willing to cut deals. So, yeah, all right. Well, I welcome everybody, and we always start these meetings off with the preamble to the Constitution. So I'd like to recite that. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. As always, it's a good reminder that the preamble is our mission statement. It is what we're trying to accomplish as Americans. Those are our five duties there in the Constitution. And the legislative package is broken into 5 titles, one for each of those duties. And tonight we're going to get to the last part of Title I, Establish Justice, with looking at the treatment of incarcerated people. And so the prison reform, the Matthew Charles Prison Reform Act, which has a whole bunch of modifications for the treatment of incarcerated people. There's a lot of them, so we're going to get right into it. As you know, as my commitment to this nonviolent revolution, I'm in the middle of a 24-day fast from starting September. I started September 21st, last Saturday afternoon, and it'll be going until for 24 days until October 15th. October 15th is the Fast for Peace, and you're invited to join me for the last 24 hours on October 15th. By giving up food and recreational intoxicants for 24 hours, drinking all the water that you want, but willingly giving something up, because that is an essential ingredient to compromise. And the Trump-Biden peace plan requires compromise. Nobody likes all 101 policies that are in it, not even me. But by all of us compromising, all of us being willing to compromise, being willing to give up something, we can all come out ahead. So people will have different objections to the 101 policies, but we'll all come out ahead. The United States will come out ahead if we work together. And so the purpose of my fast of stewardship is to try and inspire people to work together to transform this election over these 24 days. But I want to make sure that you understand what exactly it is that we're doing, and so that's why we're having these live streams, to break down exactly what is in the legislative package. This isn't one of those things where you have to pass the bill in order to find out what's in it. So just a quick update on my fast. I seem to have broken through some sort of plateau. My weight dropped down to 190 pounds, so I'm down 15 pounds in the last week. My face seems noticeably thinner. That is that's what happens on extended fasts, and it's definitely become more noticeable. Some years ago, I watched the Cesar Chavez movie, and he also did a 24-day fast in 1968. And so when the movie portrayed it, it showed the actor portraying Cesar Chavez, far into the fast, looking in a mirror, examining his face, trying to determine if he had the will to go on. But his face was far too, I wouldn't say puffy, to actually have been fasting for any sort of time. Anyways, all right, let me pull up the Trump-Biden peace plan, and we're going to jump right into this. Like I said, we've got a lot of sections tonight. So if you have questions as we go along, jump into the chat and if possible, reference the section that you have questions about. And if you want, in the description below, there is a link to the full text of the Trump-Biden peace plan. Where'd my share screen go? Okay. Subtitle C, Matthew Charles Prison Reform Act. All right, I'm just going to read the short title and findings. Congress finds the following. The United States has an incarceration crisis that has destabilized millions of Americans and is failing in its constitutional duty to establish justice. More than 2/3 of federal prisoners serving life sentences have been convicted of nonviolent crimes. Let me say that again. More than 2/3 of federal prisoners serving life sentences have been convicted of nonviolent crimes, including 30% convicted for a drug crime. And there are tens of thousands of people over the age of 50 who remain locked up as though they are elderly, sick, and pose little to no public safety risk. And approximately 97% of incarcerated Americans will be released. Therefore, it is in the best interest of all to position them to succeed when they are. All right, Section 152, modification of certain terms of imprisonment. And so this is second look legislation. Again, the standards and goals of the American Union are to recognize the inherent value in all human beings, including the opportunity and the capability for self-improvement. And so individuals who have been incarcerated for a decade or who have been incarcerated have had the opportunity to undergo self-improvement. And so this section would recognize that. Sort of like the repeal of the mandatory minimums that we talked about yesterday. This creates the opportunity for judges to judge as opposed to simply be robots that issue sentences. So one of the reasons this is needed is because the federal parole was abolished in 1984, so 40 years ago. And what this would do is allow sentencing modifications for someone after they've served 10 years. And if they're turned down after serving 10 years of incarceration, they could ask for another review after another 5 years and then another 2 years. And then a final review when they get to be 50 years of age or older. We have people that are just being thrown away in our prisons, and there's so much human potential being wasted. And it's also Byron Stevenson. I've quoted him. Brian Stevenson. I've quoted him before. And another of his good quotes is, "Each of us is more than the worst thing that we've ever done." And to which I added by definition, the worst thing each of us has done is a statistical outlier. It is not a representative data point. And so when we lock people up and throw away the key, too frequently we're using these statistical outliers to determine these stray data points to determine their life for decades. So what this section will do is allow a request of a sentencing review. Here's the terms. They have to have served more than 10 years, either they've served more than 10 years or they're serving time. Again, this only applies to federal prisons. The Trump-Biden peace plan is federal legislation, and that's where it makes changes. The Federal Bureau of Prisons, I guess it's worth noting, only incarcerates about 15% of the United States' prison population, but it does incarcerate more than any individual state does. So it is the largest. They have 122 prisons, I believe, and I don't have the statistic in front of me about how many prisoners. But all right, so who's eligible for this? After serving more than 10 years, if it was in whole or in part as part of a mandatory minimum sentence, which is repealed under the Weldon-Angelos Justice Act. So once we establish the policy that mandatory minimums are going away, give the people incarcerated under them an opportunity for review. As we said last night, I think, the average mandatory minimum sentence is 144 months in federal prison. And then C was the result in whole or part of a drug offense that is no longer punishable pursuant to enactment of the Weldon-Angelos Justice Act. So that doesn't take place till January 1, 2026. So you got the first year to sort of work through everyone else, and then when we end the federal drug war in 2026, there would be the opportunity for federal prisoners who are incarcerated to ask for their sentences to be reviewed. It is not automatic. Let me just say this is not necessarily a get out of jail free card, but it is an opportunity for people to present their case that further incarceration is not in the interests of justice. So here's what the courts would have to find. The defendant is not a danger to the safety of any person or the community, and demonstrates readiness for reentry, and the interests of justice warrant a sentence modification. They can be ordered to serve supervised release as part of their sentence modification. Drug offenses expunged. Like we talked about last night, those would be expunged. This section includes a reference to that as well. All right, factors to consider. The age of the defendant at the time of the offense. See, this is a very important statistical fact, is that most violent crime is committed by males under the age of 25, when their brains are developing, and frequently sometimes as young males try and figure out where the lines in society are, behavioral lines, sometimes they step across those lines before realizing where the lines are. And so, yes, it makes sense to make sure that there's accountability through the criminal justice system, but sentencing people to decades and decades of incarceration is not by default productive. All right, things to consider: age of defendant, age at the time of the modification, any arguments, reports by the Bureau of Prisons, and any statement which may be presented orally or otherwise by any victim of an offense for which the defendant is imprisoned, or a family member of the victim. So the judge would be required to consider anything that a victim wants to say. Does not give a victim veto power. It just requires the judge to consider. So all these other conditions. And there's a rebuttable presumption that a defendant who is 50 years of age or older, that there would be a rebuttable presumption that the defendant shall be released. Generally, people age out of violent crime for the most part. As people get older, there's less interest in doing that sort of thing. And so we have many senior citizens behind bars. All right, we already talked about the how many years for second and third application. More details about the record hearing, an annual report that the Attorney General will make regarding how many people have used this process. All right, seeing no questions in the chat. That is section 152. All right, section 153 is very simple. It's one section, repeal of the Prison Litigation Reform Act. Now, the Prison Litigation Reform Act, if you are not an incarcerated person, this probably has not impacted you. But 30 years ago, in the 1994 midterm elections, Republicans ran on their Contract with America. And included in that was a proposal to restrict incarcerated people's access to the judicial system. Bill Clinton signed the Prison Litigation Reform Act, and what it does is it makes more difficult for incarcerated people to file civil rights cases or to seek legal protections. It takes and so this has led to, basically it's given the courts just a reason to discard cases not on their merits, but just on the fact that incarcerated people haven't successfully navigated the new bureaucracy that's established. Just as importantly, the prison litigation reform also limits the court's ability to grant relief. So even when the plaintiffs succeed, court orders are difficult to enforce, and there used to be like consent decrees between over court decisions. So between prisons and inmates, saying that this is what we're going to do. However, the Prison Litigation Reform Act required that required that any court injunctions had to include a finding that the relief is the narrowest possible. And so if any of the existing injunctions, any of the court supervision that prisons were under, if it did not include that specific finding, then it went away. The Prison Legal News did a story on this a few years ago, and they said, quote, as soon as the PLRA, Prison Litigation Reform, as soon as the PLRA was enacted, prisoner advocates challenged most of its provisions as unconstitutional and lost across the board. And they concluded the PLRA will stay as it is unless Congress changes it. Okay, that's what we're doing. This is the changes we want Congress to make as part of upgrading our social contract. This provision, I just want to point out, was one of the demands from the 2018 prison strike in late summer and the fall of 2018, where incarcerated people across 16 states engaged in a prison strike, and among their demands were repeal of the Prison Litigation Reform Act. All right, the next section 154, repeal of Pell Grant restrictions on incarcerated Americans, was also one of those demands. And so this is Congress has sort of, again, back in 1994, Congress blocked incarcerated people, kicking 23,000 people off of the rolls of getting more education. People who made up 0.2% of the recipients. Even though, again, studies show that access to post-secondary education in prisons or jails can reduce recidivism by up to half. And so that saves the state money. This was penny wise, pound foolish. But it was part of the 90s getting tough on everything. So Congress figured this out a few years back. And so they have restored eligibility for incarcerated students However, instead of just repealing it, they kind of created a new bureaucracy. And so what Section 154 would do would just repeal it, and it would make up to 463,000 incarcerated people eligible for a higher education grant. Like I said, Congress already has done much of this, so most of those people are already eligible. But this will just continue to clean it up. All right. Section 155 is another demand of the prison strike. This is repealing incarceration incentive grants to the states. Again, getting tough on everything. Parole boards used to have wide latitude to release people, which created an incentive for good behavior, but Congress offered incentives to the states to pass truth in sentencing laws requiring people to serve at least 85% of their sentence. And so when the Congress authorized funding to be used for additional state prisons through the Violent Crime Control and Law Enforcement Act of 1994, Connecticut, Florida, Georgia, Kansas, Maine, Michigan, Mississippi, New York, North Dakota, Oregon, and Virginia, 11 states adopted them within a year. As best I can tell, they're not actually issuing new grants, but this would strike the existing section of law from the United States Code. All right, Section 156 is identification for people leaving incarceration. This is essentially Senator Cory Booker's New Pathways Act. And again, if the people who are incarcerated are leaving prison, we want that process to be as smooth, as seamless as possible, and help people merge back into functional society, normal society, without putting unnecessary speed bumps in the way. And so releasing someone and expecting them to, find a job, find a place to live, any of these kinds of things without identification documents can create a huge barrier to reintegration. So again, this is federal legislation. It applies to federal prisons only, and it would require the Bureau of Prisons to help prisoners obtain identification documents prior to their release. This would be for identification for U.S. citizens. That would be making sure that they have a social security card, a proof of U.S. citizenship document like a birth certificate, a photo ID card, and a debit card for their digital treasury account, which we'll talk about more in a week or so, as part of, so they can access their American Union job and their unconditional basic income. Again, one of the ways that we're going to make things easier for people to get out of prison and not reoffend is ensuring that they have a basic financial floor, a safety floor underneath them, just like every other American. For non-citizens, the Bureau of Prisons would have to help obtain proof of lawful status and, if applicable, an employment authorization document. It's all pretty straightforward in the text. But yeah, that's a good summary. All right, Section 157. This is going to address the Shin v. Ramirez decision that the Supreme Court issued a couple of years ago. And so it revolved around a couple of cases in Arizona that were kind of combined. And one of them was a man named Barry Jones, who had been sentenced to death in 1995 when a 4-year-old that had been in his care died. But he had ineffective counsel. The ineffective counsel didn't look at the evidence that the internal injuries that had occurred while the little girl was that had not occurred while the little girl was in his care. That the injuries took time to develop into the fatal infection, I believe it was. And there wasn't enough time from the time that she was in his care to the time that she died. But the lawyer didn't point this out, and so Barry Jones got sentenced to death. He's maintained his innocence since then. And then, so another part of the 1990s Get Tough on Everything was the Anti-Terrorism and Effective Death Penalty Act of 1996. And so it offered very limited reasons for bringing forward evidence which would exonerate people, and ineffective counsel is not one of them. Let's go, let me share the screen here real quick, and we'll take a look at this. Yeah, so the existing text here, this is the current law is in italics, and if it says the court shall not hold an evidentiary hearing on the claim unless the applicant shows that the claim relies on a new rule of constitutional law made retroactive to cases on collective review by the Supreme Court that was previously unavailable, so new facts, a factual predicate that could not have been previously discovered through the exercise of due diligence. And that's it. Those are the two reasons why you're allowed to request a new evidentiary hearing. And the fact that you had ineffective counsel both for the original trial and on appeal is not reasons to, if your existing counsel didn't bring forward, the Supreme Court said, too bad, so sad, you don't get to do it. So you just have to sit there. So to correct this Shin v. Ramirez decision, we add a third bullet point or a finding of ineffective assistance of counsel. There you go. That's pretty straightforward. Just as a footnote to this, Barry Jones was released in June of 2023 when he agreed to plead guilty and have his sentence changed to time served. So that was the deal. Didn't matter. That was the deal. Plead guilty, and we'll let you go. We've talked about the coercion of plea bargains already. All right, Section 158, habeas hearings restored. This is another Supreme Court decision. This is Jones v. Hendricks, and this is more fruit from the tree of the Anti-Terrorism and Effective Death Penalty Act. This case, son Jones v. Hendricks, Marcus Jones was a federal prisoner who was convicted in 2000 of possessing a firearm after being convicted of a felony. But in 2019, the Supreme Court said that this has to be knowingly, and Jones tried to challenge his conviction, saying, I did not know that I was a convicted felon. It wasn't communicated to me. There have been, and anyway, so the evidence was that he had not in fact been knowingly violating this section of law. And as one of the claims in the bullets in the last one, right, we said was a new rule of constitutional law by the Supreme Court. So you would think that would be enough, but here's what the next section says, that the Supreme Court ruled that essentially, once again, too bad, so sad, you've already used up your chances, and but the existing protections for habeas hearings that were there prior to the passage of the Anti-Terrorism Effective Death Penalty Act, Congress did not change the existing protections. The court has interpreted it in that way, and so we're going to clarify the law to clarify that those habeas remedies are still available. Both of these cases really hinge on this question of accuracy versus finality, right? What is justice? Is justice being able to clap your hands and say, okay, that's done, or is justice about getting the right outcome? And there is validity to the point of view that a resolution needs to be part of justice. But in these cases where injustice has been done, how can you ignore that? How can you say, well, we just don't want to know? how many wrongfully incarcerated people there are locked up. Again, that's not justice. So, all right, moving on. I'm gonna pick up the pace here. Section 159 is addressing prison gerrymandering. As you know, every 10 years, the U.S. takes a census to apportion congressional districts, and prisons are frequently built in low population density areas where when you house, hundreds, thousands of people together, creates a population bubble. And how do you count those people? Are they counted as living there in that section, even though they're only there temporarily? And this is a legitimate policy question, and it's similar to the question of college students, right? Where do you count college students as living? And well, in the 1950s, the census began counting them at their colleges. Now, there's an obvious difference between colleges and prisons in that college is voluntary. You choose where you're going to end up. Prison, not so much. Prisoners have very little say. So before the last census in 2020, the Census Bureau asked the public to weigh in. They got 77,887 comments on this issue. Out of those 77,877 comments, all but 24 supported counting incarcerated people at their former address. And so that's what this section would do, effective beginning with the 2030 decennial census. It would count them at their last usual place of residence before incarceration. Some of the side effects of prison gerrymandering, right, is that you shift people out of maybe the cities where they live. You stop counting them for representation purposes there, and then you count them in the rural areas where they don't. And so that's why it's called prison gerrymandering, to roughly approximate the party affiliations of the districts. It is frequently more democratic areas that of cities where incarcerated people are from, and then they are counted as living in a Republican rural area. Well, it's not always true, but it's a general truth. Again, so this is why it's gerrymandering and why we can correct it. So that's what this section does. All right, we'll move on to section 161. Seeing no questions in the chat, but I see the TC says hi. All right, we'll just read these findings real quick. Phasing out for-profit prisons. Congress finds the use of private prisons leads to an increase in the number of people incarcerated, according to a 2020 paper by researchers at Washington State University. A 2016 Inspector General's investigation into private prisons found that they, quote, incurred more safety and security incidents per capita than comparable Bureau of Prisons institutions. 3. In his book American Prison, Shane Bauer documented workings inside a private prison in Louisiana and the perverse financial incentives that encourage the corporations to understaff facilities, deny good time in order to keep prison beds filled, cut corners at the cost of safety, and misreport serious incidents. 4. Private prisons hold less than 10% of incarcerated people in the criminal justice system, but as the United States moves in the direction of ending mass incarceration, we must rethink this along with the other pieces. And 5, incarceration, when necessary, is an essential government function that should not be delegated to private entities. So the purpose of this part is to eliminate the core conflict between the duties of the Constitution and the financial incentives of for-profit prison. So good news, when Joe Biden took office in January of 2021, he issued an executive order directing the phasing out of the use of private prisons, and the Bureau of Prisons accomplished this. At the end of 2022, in 2023, they were no longer utilizing for-profit prisons. That's the good news. All right, the bad news is executive acts can change based on who the executive is. So when the occupant of the Oval Office changes, so can the executive acts, which is why this would codify that phase out, codify the prohibition on using for-profit prisons to incarcerate people. That's one half of it. The other half is, yes, the Bureau of Prisons has phased things out, but the U.S. Marshals Service has not. The ACLU is reporting that some 20,000 people are still held through what they call the pass-through loophole, which is the Marshals Service hires a state or a city hires them, and then that state or city contracts with the for-profit prison. So this is their pass-through loophole. And so you can see in writing a new section of law, section 416, and all court correctional services at each correctional facility used by the Marshal Service shall be performed by employees of the federal government, except they may enter and maintain a contract with a facility operated by a state or unit of local government if the core correctional services are performed by employees of such state or unit of local government, and the facility meets all constitutional, federal standards. So this would close that pass-through loophole. And this is a phase in. It's not a snapping your fingers. Contracts frequently extend for multiple years, and so section 163 has the transitional provisions to require them to take the appropriate actions to phase out these contracts. Again, the Bureau of Prisons has already done this. This is just codifying it after the fact and making sure that this door that has been closed stays closed. All right, part 2, restricting the use of solitary confinement. Solitary confinement. All right, well, let's read the findings here real quick. Congress finds the following. 1, the United Nations Office on Drugs and Crime has issued the Nelson Mandela Rules, the United Nations minimum standard rules for the treatment of prisoners. And the use of indefinite or prolonged solitary confinement for more than 15 days is defined as a form of torture. Rules 43 to 45 define restrictions for solitary confinement. 2, in the summer of 2019, the United States had more than 155,000 incarcerated people who had been in solitary confinement for 15 days or longer, including thousands for more than 3 years. 3, a 2014 study published in the American Journal of Public Health found that self-harm is strongly linked to being in solitary confinement, where inmates punished by solitary confinement were approximately 6.9 times as likely to commit acts of self-harm. And 4, the Department of Justice review on solitary confinement, published in January 2016, summarized their conclusions by emphasizing, as a matter of policy, we believe strongly this practice should be used rarely, applied fairly, and subjected to reasonable constraints. And so that is what the purpose of this section is, to reduce the use of solitary confinement, recognizing the redeemability of every human being, and improving America's moral standing in the world by bringing us up to the United Nations standards. If you're interested in learning more about solitary confinement, I would recommend the book Hell is a Very Small Place, which has history and writings by those who have experienced solitary confinement. And this is not new. Charles Dickens, he did a tour of the United States in 1842, and he visited the Eastern State Penitentiary in Pennsylvania, and was shocked by the conditions that were there. Later that century, 1890, so 134 years ago, the Supreme Court recognized the harm that solitary confinement caused to people's mental health. And some prisoners, they found, quote, became violently insane. Others still committed suicide, while those who stood the ordeal better were not generally reformed. and in most cases did not recover sufficient mental activity to be of any subsequent service to the community. We are inflicting unnecessary suffering on people, and we know this. This is not, again, this is not new information that we're just figuring out. We know this, and we're continuing to allow this injustice to exist. President Obama, he restricted the use of solitary confinement against juveniles in 2016. And he wrote an op-ed, said, quote, "The United Nations is a nation of second chances, but the experience of solitary confinement is too often undercuts that second chance. Those who make it out often have trouble holding down jobs, reuniting with family, and becoming productive members of society. Imagine having served your time and then being unable to hand change over to a customer or look your wife in the eye or hug your children." Yeah, this is the mental, humans are social creatures. We are not designed to live in isolation for long periods of time. And, many people in prisons already have some mental health issues, and solitary confinement does not help make them better. So, all right, the UN. So I guess I also want to say that there's only a dozen states or so have reformed, restricted, abolished the practice of solitary confinement. Colorado did this like 15 years ago or something, and they've seen huge reductions in assaults against staff. So the outcome is good, right? This is a positive change. This is a win-win scenario. But let's just talk about definitions. So what this does is this sets a new floor, defining solitary confinement as 22 hours a day in isolation, because this is the Nelson Mandela rules. That's what they say. You can pick a different definition. I've seen a variety of them, but 22 hours a day in isolation is the UN definition. So we're going to start there, and then provide legal protections, legal framework, going back to what the Department of Justice Review said, making sure this practice should be used rarely, applied fairly, and subjected to reasonable constraints. So let me go ahead and share the screen again here, and we'll start looking through this section. All right, so what is solitary confinement? We've got some definitions here. They're all basic definitions. Emergency confinement, federal agency, federal facilities, incarcerated person, medical solution, medical staff, psychiatric vulnerable person is incarcerated people who are under 21 years of age. Again, brains are still developing at that point, and extended isolation can be very detrimental to the process. I may have spoken briefly about Caleb Browder, a young man who spent 2 years in isolation, in solitary confinement, and on Rikers Island as a teen, and it so disturbed his mental health that he committed suicide when they finally dropped the charges against him after years of incarceration, which was a result of his family not being able to raise money for his bail. All right, so vulnerable person is someone who's under 21 years of age, has a serious mental illness, has a developmental disability, significant neurocognitive impairment, or has a serious medical condition which cannot effectively be treated in solitary confinement, or is pregnant, has given birth, suffered a miscarriage, or terminated a pregnancy in the previous 45 days. So these are the vulnerable people. All right, now we're getting into subsection B, restrictions on the use of solitary confinement. Let's see. Okay, solitary confinement. I just want to repeat this definition, means the involuntary confinement of an incarcerated person for 22 hours or more per day. It does not include confinement due to a faculty-wide or facility-wide or unit-wide lockdown that is required to ensure the safety of incarcerated people and staff. So if there's a lockdown of the prison or something like that, which does happen, then that is not a violation of this section. But it's also involuntary confinement. Sometimes there are cases in prisons where people seek voluntary confinement as a way of trying to protect their safety. And so that would not be prohibited under this. It's only involuntary confinement. All right, so the restrictions. No vulnerable person, except for medical seclusion. No person, you can't place someone into solitary confinement except for disciplinary reasons pursuant to subsection C, which we're going to read in just a second here. No incarcerated person can be placed for more than 15 consecutive days or 30 days in any 60-day period. This is important. I want to say it was New York State some years ago had a restriction that said you couldn't be in solitary for more than 10 consecutive days. So they would lock them up for 10 days, put them back in general population for 1 day, and then kick them back to solitary for 10 days. And as you can imagine, not having a stable living situation is also not beneficial to people's mental health. So this cap on 30 days in any 60-day period would help prevent things like that. All right. 3, no person placed in solitary confinement shall be subjected to corporal punishment, placed in a cell or a holding facility living space that is dark or constantly lit, or lacks functioning sanitary facilities, proper ventilation, or temperature monitoring. Cannot be denied access to appropriate medical care, including emergency care, or given reduced access to food, water, adequate clothing, or any other basic necessity. No variation of food from the standard menu shall be permitted without the incarcerated person's consent, except for a limited period, not to exceed 7 days, for an incarcerated person who has used food or food service equipment in a manner that is hazardous to people, and provided that the food supplied is healthful, palatable, and meets basic nutritional requirements. I've communicated with incarcerated people about this section and trying to make sure that their concerns were addressed. And so that's why this section is here about setting standards for the holding cell. The food service thing is, there is this thing called Nutriloaf, and you can look it up, and it's basically like a loaf of bread that is supposed to meet all of your dietary requirements, and it is just specifically designed. It's designed to be eaten without utensils, and it's designed to be plain and bland and tasteless. And the state of Vermont has prohibited Nutriloaf as being cruel and unusual punishment. So, anyways, that's the word palatable that's in here. So this would this would prohibit Nutriloaf. All right, now we're getting into section C, disciplinary use of solitary confinement. This is the rules and procedures before you can sentence a person to the prison within a prison. You have to give them due process. It can't just be on a whim. It can't just be capricious. It can't just be with no reason whatsoever. So if you're gonna use it, there has to be due process. And it's limited to offenses, A, causing or attempting to cause serious physical injury or death to another person, compelling or attempting to compel another person by force or threat of force to engage in a sexual act, C, leading, organizing, inciting, or attempting to cause a riot or other serious disturbance that results in a taking of a hostage, major property damage, or serious physical harm. and D, attempting to escape or facilitating an escape. And so again, if you're gonna send someone to the prison within the prison, there has to be something other than a guard saying, well, I didn't like the way you looked at me or you talked back to me. Bam, you're going to the hole. Again, this is, yeah, we can fix this up. We should fix this up. Again, this is a widely recognized problem in the United States, and Congress is failing to act. So we're going to help. All right. 2, an incarcerated person shall not be placed in solitary pending investigation unless there is certain extenuating circumstances. And if they have not had their due process yet, you gotta make sure that it's reviewed. The decision is reviewed within 24 hours, that they get an initial hearing within 72 hours, and whatever the maximum term of disciplinary solitary confinement is permitted, they shouldn't be in investigative solitary confinement for a longer period. And somewhere in here is something includes that time any investigative solitary confinement should be applied toward any sentence of disciplinary solitary confinement. All right, due process. A disciplinary hearing conducted by a neutral decision maker. Spell out some people who do that. Making sure that the incarcerated person can represent themselves or be represented by any other student, attorney, law student, paralegal, community advocate, or other incarcerated person of their choosing. The term jailhouse lawyer, I think, is fairly well known. There are incarcerated people who, with all this free time on their hands, are able to educate themselves on how the system works and have the ability to share that information with others. So that's included as something that they can do. And if they don't have their own representative, they can be offered the assistance of a representative. And spell out the Department of Justice section divisions that would assist with that. All right. Before hearing, making sure that everybody gets notice of what is all the evidence, what is the reason for the hearing, all those kinds of things. The hearing should be videotaped unless a incarcerated person refuses in writing. The decision maker gives a written determination specifying the finding, the summary of the testimony, and the evidence relied upon in reaching the finding. Again, this is basic due process, to have a system of law and justice as opposed to a single individual's whim, as is currently the case. All right. Okay. And if the hearing officer thinks that the person has symptoms of a mental illness, then there shall be a competency hearing as well. All right. Disciplinary solitary confinement may only be used if the hearing officer concludes that other available sanctions are insufficient to serve the purposes of punishment. So try other things first, and if those are insufficient, then we can get to the prison within the prison. Vulnerable person described in ERF, that's pregnant people and somebody with a medical condition, can be placed in medical seclusion. All right, investigatory solitary confinement should be credited towards the sentence, and ordinarily these sentences for offenses that arise out of the same episode should be served concurrently. All right, 7, during the last 180 days of an incarcerated person's term of incarceration, you should avoid placing the person in solitary confinement. Again, as you're merging back into normal society, let's not put mental strain on people. Instead, trying to help not put extra roadblocks in their way. So avoid solitary during the final 6 months of a person's sentence. And as well, consider early release from solitary where appropriate. All right, D is medical and health exams. Again, the Supreme Court recognized back at the end of the 19th century the mental harm that solitary confinement causes. And so this requires regular medical and mental health examinations with a clinician meeting with the person on a daily basis, making sure that they, in emergency confinement, get an initial evaluation within 2 hours and a comprehensive one within 36 hours. Medical seclusion is, again, if there is medical, if there are medical reasons, you need, contagious disease, things like that. Medical seclusion is for that sort of situation, including a person who is identified as having at a risk of suicide, and to help maintain people's dignity. Their clothing may only be removed if an individualized assessment. So you got an assessment first. You can't just do it on a person's whim of humiliating and degrading the person by taking away their clothing. And provide them with suicide-resistant garments that are sanitary, adequately modest, and appropriate for the temperature. Making sure that people are under observation, and it can be done for the fulfillment of disciplinary solitary confinement. All right, and so this will be a new section to the law. Sections A and B shall be effective September 30th, 2025, so 1 year after passage. And A and B are the restrictions. So the restrictions will be phased in over a year. All right. Seeing no questions in the chat. Let's see. And all right, the last section here, right on time here, 173 is the Civil Rights of Institutionalized Persons Act, which was passed in 1990. Before we started getting tough on the parties competed to see who could be tougher on crime. Before that, we passed the Civil Rights of Institutionalized Persons Act, and this department basically looks out for the civil rights violations, but it also limits individual causes of actions for mental injuries to physical and sexual assaults. And so solitary can absolutely inflict mental injury, and so this provision is offered as a safe harbor. You cannot bring a federal civil action unless a showing that they're placed in solitary confinement in violation of this section 172. And once again, that would be effective in 1 year. So, all right, I think that's going to do it tonight for talking about prison reform. And tomorrow we're going to move into Title II, ensuring domestic tranquility and a 10-year truce on guns and abortion. So please join us tomorrow evening at 7 p.m. Eastern Standard Time. All right, thanks very much, and have a great rest of your evening.